Your Lordship, may I be permitted to mention a matter? Should this matter, I was thinking if it could be kept tomorrow, as you know, the London Lower Court has directed to detach the bank accounts.
Attach the bank account. What is the matter about?
Lordship, it's the Union of India versus Jaya, AP for 143 of
It's a 34, 37. What is it?
Section 54.
34. So execution proceedings are there.
Lordship, but I was reading that if the matter could be kept tomorrow.
Madam, 34, I'm not listing it tomorrow. No upgradation on 34.
Your Lordship, leave be given to mention one EC com for withdrawal.
Pass over. Pass over.
Okay, for the award holder, Millard.
Yes.
On the last occasion, Millard, with this matter, when it came up before your lordship, Millard,
Yes.
there was one question because, Millard, in the Millard, we had already served notice. Millard, what had happened, Millard, after passing of the award, this is an 12-way award, Millard. Under section 12-way, the award was signed by the arbitrator. Now, thereafter, Millard, we entered during the pendency of the section 9 application and the execution, we entered into a settlement. It was not settlement in that sense. It was really for repayment of the awarded dues in a certain manner. Now, Millard, it had fallen from your lordship whether, Millard, as a consequence of that settlement, Millard, whether the decree or the award, Millard, is extinguished. Millard, may I, in that sense, Millard, lordship will kindly, Millard, once take, Millard, order 21, rule 2.
Order 22, rule. Yes.
But payment out of court to decree holder. That where any money payable under a decree of any kind is paid out of court, or a decree of any kind is otherwise adjusted in whole or in part to the satisfaction of the decree holder, the decree holder shall certify such payment of adjustment to the court whose duty is to execute the decree, and the court shall record the same accordingly. 2. The judgment debtor or any person who has become surety for the judgment debtor also may inform the court of such payment which has not been done. They have not come up for any valid certification. Valid 2A. No payment or adjustment shall be recorded at the instance of the judgment debtor unless the payment is made in the manner provided in Rule 1, or the payment or adjustment is proved by documentary evidence, or C, the payment or adjustment is admitted by or on behalf of the decree holder in his reply to the notice given under sub-rule 2 of Rule 1 before the court. The 3, any payment or adjustment which has not been certified or recorded as aforesaid shall not be recognized by the court executing the decree. So therefore, if your lordship kindly takes the order under in section 9 application, page 43. May I please?
Yes.
The petitioner does not want to proceed with the matter as parties have settled the issues involved in this application. That was a section 9 application by entering into a further terms of settlement dated so and so. Upon recording such facts, the application is dismissed as withdrawn. Copy of the terms of settlement is taken on record. But lordship will kindly take simultaneously. By that time, the execution, it had become enforceable. Therefore, the execution proceeding was also filed, but that also, on my submission, it was withdrawn. If Lordship kindly takes the next page. Learned counsel for the award holder states that the matter stands settled between the parties by settlement dated so and so. In view of such development, the award holder does not wish to press the present application at this stage. Accordingly, the application is dismissed as withdrawn with liberty to the award holder to initiate appropriate proceedings in accordance with law if necessary. So therefore, my lord, it is only as, my lord, in view of the agreement for repayment of the awarded amount or a decretal sum,
Right.
that, my lord, I had withdrawn this, my lord, the execution application subject to, my lord, if conditions are, my lord, arise or circumstances so arise, to file again. My lord, may I in this regard, my lord, rely upon a judgment of Honorable Supreme Court 2000 volume 7. But it elaborately, my lord, deals with this situation, in fact, withdrawal also, and what is the effect of a withdrawal. The facts are slightly different. There was a decree for, my lord, possession in an eviction suit. Lordship will kindly take paragraph 6. And this is the point of consideration framed by the Honorable Supreme Court, my lord. In view of this, Lordship has got, sorry. Sorry. That in view of these contentions, the point that arises for consideration is whether, in view of the compromise entered into between the parties and execution of the new lease deed, the ex parte decrees dated so and so got extinguished, and as such, the appellant cannot get possession of the premises in execution of the existing decree. Paragraph 7, it only, 7 I'll place it. It may be pointed out here that after the rights of the parties are crystallized on passing of a decree by a competent court, in law, they are not precluded from settling their disputes outside the court. But to have the compromise recognized by a court, it has to be recorded under Rule 2 of Order 21, CPC. The consequences of not having it so recorded is contained in Rule 2.3 of Order 21, CPC. Rule 2 and, it is quoted.
Yes.
Thereafter, paragraph 8.
Yes.
Subrule 1 of Rule 2 noted above requires that where any money payable under a decree is paid out of court, or the decree of any kind is otherwise adjusted in whole or in part to the satisfaction of the decree holder, he shall certify that payment or adjustment in the court which is to execute the decree, and the court is enjoined to record the same. Subsection 2 thereof enables the judgment debtor or a person who has become surety for him to inform the court of such payment. Subrule 3 prohibits every court executing the decree from recognizing a payment or adjustment which has not been certified or recorded by the court under the aforementioned subrules. Thereafter, Lordship will kindly take paragraph 14. Well, I'm not placing it. Lordship will kindly take note of paragraph 12 as well. When one Privy Council decision of is quoted, I have the judgment, but I'm not read it. Paragraph 12. As long back as 1939, the Privy Council in Odd Commercial Bank Limited versus Thakurain bin Basini Quer laid down the law on the subject as follows. If it appears to the court, acting under section 47, that the true effect of the agreement was to discharge the decree, forthwith in consideration of certain promises by the debtor, then no doubt the court will not have occasion to enforce the agreement in execution proceedings, but will leave the creditor to bring a separate suit upon the contract. If, on the other hand, the agreement is intended to govern the liabilities of the debtor under the decree and to have effect upon the time or manner of its enforcement, it is a matter to be dealt with under section 47. In such a case, to say that the creditor may perhaps have a separate suit is to misread the code, which, by requiring all such matters to be dealt with in execution, discloses a broader view of the scope and functions of an executing court. Their lordships are in agreement with the statement in the case of Govardhan Das that in numerous cases, a compromise between the decree holder and the judgment debtor entered into in the course of execution proceedings which was duly recorded has been enforced, and they are not of the opinion that the practice which is both widespread and inveterate is contrary to the code. They are of the opinion that in the present case the compromise can and should be enforced in these execution proceedings. Let paragraph 14 thereafter. In the case where parties compromise after the decree in a case has been passed, the effect of the compromise on the executability of the decree depends upon the intention of the parties, which is a mixed question of law and fact and has to be determined by the executing court on an application under section 47, on the interpretation of the decree and the compromise in the light of the facts and circumstances of each case. If on such determination it is gathered that the intention of the parties is to extinguish the decree, and either the decree holder or the judgment debtor got the compromise recorded under order rule 2, order 21 by the court whose duty is to execute the decree, the execution of the decree cannot be proceeded with by the executing court. But if the intention of the parties is to keep the decree alive and to give effect to it in the manner agreed upon between the parties in the compromise, the decree will be given effect to accordingly or executed as is depending upon whether the compromise is recorded by the court as aforementioned or not. Paragraph 15, Millard.
Yes.
In the instant case as noted above, after the decree was passed in favor of the appellant for ejectment of the respondent, the parties entered into a compromise during the pendency of the execution proceedings, which inter alia mentions that a portion of the suit premises was handed over to the appellant, and in respect of rest of it, the appellant was allowed 3 years to vacate the suit premises and hand over possession of it to the appellant, for which an agreement of lease was also entered into between the parties. Clause 6, I'm not referring it to, it is not relevant. Lord, there are the just after the quotations, Millard, on filing of the compromise. Lordship has found it in the next page. On filing of the compromise in the court, the EP was dismissed as not pressed. Thus, there is thus no recording of compromise as contemplated under Rule 2, Order 21. Therefore, the court cannot recognize the compromise having regard to the language of Subrule 3. Paragraph 16. However, the contention of the respondent based on the finding of the executing court that the parties have entered into a new lease in respect of the suit premises on so and so date is as a new lease was entered into between the parties, he is entitled to protection of the act, and unless a fresh decree of eviction is passed against the respondent by a competent court, the appellant cannot evict him from the suit premises by executing the existing decree. On a plain reading of the decree, the memo of compromise, and on the facts of this case, we have no doubt that the existing decree is not extinguished. The parties agreed upon the mode and time of enforcement of the decree by satisfying the decree in part and postponing the execution of the decree in respect of the remaining part by 3 years. Now, paragraph 18, Lordship will kindly take, Millard, that also covers, Millard, this situation. However, the contention of Mr. Shiva Subramaniam is that as no specific procedure or method of recording the adjustment has been prescribed under the rules, the order dismissing the EP as withdrawn must be taken as recording of the compromise by the executing court. We are afraid we cannot accept this contention of the learned counsel. It is true that no specific procedure or formula is prescribed for recording the adjustment in the said rules. What is required under Rule 2 is that the court should take cognizance of the fact of the compromise and pass appropriate orders accepting or giving effect to it. Admittedly, no such order is passed in this case, even assuming without so holding that the order amounts to recording of such compromise, inasmuch as it did not have the effect of extinguishing the decree. As held above, the decree has to be executed. And the compromise indicates that there has been a part satisfaction of the part of the decree, and in regard to the remaining part, they contemplated granting time for 3 years to the respondent for vacating the premises. Even so, this does not justify the conclusion that the decree has become inexecutable with regard to the rest of the suit premises. And that is all. So, in the case, in the facts of this case, my lord, if your lordship kindly takes, my lord, the terms,
Yes.
was entered on first, my lord, it is at page 31. Sorry.
Yes. Yes.
Lord, 1st of April 2025. Lordship will kindly take, Lord, page 34, second last paragraph, whereas the opposite party is my lord, one important thing, my lord, what had happened, my lord, earlier it was a partnership firm. And this settlement also records that it has thereafter been, my lord, converted into a company. So that is recorded. That is why, because execution has been filed in the name of the company, which has also signed the settlement. That is why I'm placing this, my lord.
No, the 12-way settlement, who are the parties?
The partnership firm and the partners
So the partnership firm,
was there,
right.
and this records that thereafter it has been converted into a company.
But you are seeking execution of 12-way. You are seeking execution of the mediation,
Award.
the award.
Yes.
So in that, who are the parties?
The partnership firm
So
and the partners.
that will remain.
Yes. The opposite party, my lord, I'm just placing this form. The opposite party is incorporated as a company under the Companies Act, having its registered office near so and so. The opposite party, number 4, personally jointly agree, admit, and confirm due performance. Yes, my lord, thereafter the paragraph, whereas the parties herein have entered into a business transaction. At that given point of time, the opposite party was a registered partnership firm and was carrying on its business under the name and style of Aleka Constructions. Lord, thereafter, my lord, lordship will kindly take, my lord, page 37, the terms.
Yes.
Lord, the effective date of the instant settlement shall be the date of signature. Number 2, the parties have herein have jointly agreed rupees 28,71,469 as full and final amount for settlement payable by the opposite party in favor of the award holder as per the payment terms so and so. 2A, the opposite party will pay the said full and final settlement amount of rupees so and so within a period of 36 months from the effective date to and in favor of the award holder on the monthly basis, interest free. Thereby, the entire payment will be made in the schedule provided in the table. Let B, at page 38, just after the table, in the event of non-payment of 5 installments by the opposite party, as per the aforesaid terms, the default will occur on the part of the opposite party, and the entire settlement amount of rupees so and so will immediately become due and payable by the opposite party, and then the opposite party will be liable to pay settlement amount together with interest chargeable per 18% per annum. In that event, the date of default will be taken as 21st August 2024. This is for the purpose of calculation of interest. Paragraph 3, next page, 39. Number 3, upon payment of the entire full and final settlement amount, all the disputes and differences of whatsoever nature between the parties in respect of their instant dispute shall stand resolved in full and final, and all cases, including but not limited to civil, criminal, quasi-criminal, etc., whatever relating to all disputes between the parties shall stand settled, and the parties will withdraw and drop those proceedings. 4, the present terms of settlement is in furtherance of the decree dated 30th of August 2024. In the event of any consistency of arise thereafter, yes, in the event of any consistency or arise of any dispute between the parties relating to subject transaction involved herein, the award holder and the opposite party mutually and unconditionally agree that the present terms of the settlement shall also prevail and shall supersede all terms of the decree so and so. Thereafter, the next paragraph, may I only please the last 4 lines. On such, Lordship has got it in the next page. On such, the settlement amount shall be replaced with the principal amount and will become due at once. The opposite party jointly and shall pay interest at the rate 18% per annum. In the event of default, will taken as so and so date. And 7, page 40, paragraph 7. This terms of settlement is final and binding upon the parties hereto and fully and finally settles all claims, entitlements, and disputes between the parties and or relating to sale and purchase of goods, including those forming the subject matter of the application, as also all other matters not covered by the said application. The copy of account ledgers, my lord, it is given. Now, most importantly, my lord, paragraph 8 thereafter. In the event the opposite party or any of them make payment in terms of payment schedule as contemplated in paragraph 2A above, the decree shall stand satisfied and will become inexecutable in the eye of law. So it is only in the event of satisfaction of this terms of settlement that the decree became inexecutable. And besides this, my lord, this is one, my lord. Secondly, my lord, there is no recording as my lord was placing the judgment under order 21 rule 2, or therefore, my lord, in my humble submission under order 21 rule 2 sub rule 3, my lord, that cannot even be taken cognizance of. And today, my lord, they have also not filed any application under the section 47 for taking this issue also. Now, my lord, as far as the default is concerned, because then in default of payment of 5 consecutive installments, the entire amount becomes due and payable. Lord, therefore, after the default has happened, my lord, I have come before the executing, my lord, before this honorable court for executing the decree, because once the entire amount is become payable and they have not paid. Okay. Notice twice. Lord, we have served them notice twice.
Affidavit of service taken on record despite sir. They have been served
Yes, my lord, we have served twice, but they have not, my lord.
despite service. None appears for the response. These two are delivered. One is not. The last one. It's just item dispatched. The last.
Sorry, my lord, I could have.
See the last page. You have the affidavit, right?
This is the second one. But the second affidavit, my lord, it was delivered, my lord. The first was of
Second is delivered.
first was
The
of
second,
24th February.
this thick one is the last one. 26th.
Look, this is affirmed on 6th of March. The first was of 24th of February.
Affidavit of service dated 6th of March 2026 and 24/2/2026. Both are taken on record. The affidavit of service dated 6th of March 2026 records that all the respondents have been served despite service. None appears for the respondents. Full stop. The petitioner seeks execution of the mediation settlement agreement dated 30th 8 2024 arrived at between the parties under section 12A of the Commercial Courts Act.
And read with section 30 of the Arbitration and Conciliation.
Read with section 30 of the Arbitration and Conciliation Act 1996. Full stop. Learned counsel for the award holder submits that the parties subsequently entered into an agreement dated 1/4/2025 whereby the outstanding payments under the said settlement were scheduled to be paid in terms of clause 2A, right? Full stop. However, the award debtor has failed to comply with the terms of the said settlement agreement and has failed to make the payment as per the schedule. Full stop. In view thereof, the award holder has approached this court seeking execution of the mediation settlement agreement dated 30th 8 2024. full stop. 30th August.
Okay.
Service be effective upon the award data. Affidavit of service to be filed on the next date. Award data shall file affidavit of assets,
But I was only
giving
humbly praying
details
for
of the
that-
assets and other movable and immovable properties with an advance copy to the award holder.
May I only pray for one more thing, my lord, attachment of the bank accounts. My lord, twice we have served, my lord, they have not. My lord, despite service, my lord, they have not appeared. Even in the section 9 application, they have appeared. The execution, they have appeared, and this terms of settlement was filed. My lord, it is indicated at paragraph, my lord, 29 at page 11.
Paragraph 29.
Page 11 of the affidavit in support of tabular statement. The last, my lord, line, my lord, the PAN.
You only have the PAN number.
We only have the PAN
It's
number.
very difficult. I have done it. You have to get me the details. I have done that, and then it comes back to me because they're not able to find
My lord,
out
in that other matter, my lord, which I was also there, my lord, what had happened, my lord, thereafter, your lordship had directed the jurisdictional, my lord, officer to effect that. My lord, ultimately, it was done.
I
I remember, my lord.
it's more difficult. Get me the bank details. I'll attach it.
Lord, the only difficulty is, my lord, even if I approach any authority or the
Then
bank,
let them
lord, they will not give me any.
Then let them file their affidavit. Let them file their affidavit.
Great.
List after 4 weeks.
Sorry for the indulgence. May I mention one matter with
Not
your
at this stage.
lordship?
Not at this stage.
কোথায় গেল নামটা কি জানি
And there were 2 passovers. Just take those passovers. 2 passovers. I'll just finish.
Lordship, item 1 and 2, I wish to withdraw the matter. The matter has been settled between the parties.
What is your name, counsel? Call him. Jabi. What is your name? Devrat Sahu. Give your how many years in practice?
Lord, more than 10 years.
Give your name and number. Learned counsel for the petitioner seeks to withdraw the present petition since the matter has been amicably settled between the parties. Full stop. A copy of the instruction given by the client to withdraw the present petition is handed over. The same is kept on record. The present petition is dismissed.
Lordship, warrants to be discharged.
Warrant, if any, shall stand discharged. Interim order, if any,
1 and 2.
shall stand vacated.
Action.
Two also same.
See,
There's a warrant there also.
warrant there.
Same order.
Four is my application for execution. My lord, award dated 28th December 2022. My lord, 2 years have passed. We have filed this application. So, my lord, there needs to be an order for service under Order 21, Rule 22.
Petitioner is seeking execution of the award dated
My lord, 28th December
28th
2022.
December 2022. Full stop. The execution petition has been filed beyond the statutory period of 2 years. Full stop. The department is directed to effect service upon the award letter in terms of Order 21, Rule 22, 1 of the Civil Procedure Code 1908. Full stop. The department shall file a report on the next returnable date. List on.
Deeply obliged.
My application for execution of an arbitral award dated 24th of January 2024. Since this application has been filed within 2 years, No service will be required, your lordship. I'll be pressing for an order in terms of the tabular statement D, prayer D, because my lord, it will be apparent from the award of the prayer D. The subject matter of the arbitration was 5 flats, which I have pleaded in my application at paragraph 13.
Where's the asset?
My lord,
Where's the detail of the asset?
my lord, the asset has to be filed by the
Don't ask for it right now. Let
my
me
lord,
file.
the only asset as of now which we are aware is the 5 flats, because that was a money decree of a sum of rupees 50 lakhs
Wait
in
for
favor
them
of.
to file their affidavit of asset.
Well, in the meantime, the protection may be passed so
What
that
protection, sir?
so that these 5
This is
flats
a-
may not be.
I can't give a blanket order. Where are the details of the flats?
My lord will kindly come to page number 5 of my application at.
Yes. Are they the owners of these flats?
Yes, they are the developers. And what has happened, your lordship?
Let them file their affidavit. Take down. The petitioner pays for execution of the award dated
24th of January 2024.
24th of January 2024. Full stop. The application has been filed within 2 years from the publication of the award. Service be effected upon the award debtor. Full stop. Affidavit of service be filed on the next date. Full stop. Award debtor shall file affidavit of assets, giving details of the assets and other movable and immovable properties with an advance copy to the award holder. List on. After 6 weeks.
6 weeks. Grateful, your lordship.
Lord, Lord, this is my execution application, my lord, money award, my lord, of 13th September 2025. Lord, 34, my lord, they have filed, my lord. Matter is directed to appear, my lord, in the month of April, my lord.
I hand over the order to the last one.
Yes, yes.
Very
No
short
stay.
point.
They have not.
It's a very short point, and the respondent is really with the court authority. But even if we want, we cannot go anywhere.
My lord, let the execution application be served upon them. My lord.
Yes, but let them serve it. But it may be taken up with the 34 application, my lord. If your lordship finds that it is payable, my lord, then we have to go. It's a very short point. The 34.
Award is of which year?
2025.
2025 September.
September 25.
Below in the list. The petitioner prays for execution of the award dated 13
September 20.
September 2025. Full stop. The application is filed well within the statutory period. Full stop. Service be effected upon the award debtor. Full stop. Affidavit of service to be filed on the next date. Award debtor shall file affidavit of assets giving the details of
Lord, I
the
am serving the copy here now. I have a copy.
learned counsel for the award debtor seeks and is granted. How much time to file? वो line हटा दो service.
Statutory authority, my lord, if it let assets, my lord,
You have to give whatever the statutory authority also has assets.
But I know, my lord, but if your lordship kindly takes up with the 34, my lord, because my lord, there is no chance of, my lord, the court authority.
They have not sought for
escaping
stay,
the-
my lord. They did not ask for stay.
You get a stay on the award.
Yes.
If your lordship kindly keeps it in the month list of April, my lord, in the meantime, will take.
You should have filed your 36.
Yes.
Why didn't you file a 36?
I cannot say
But
that.
80 lakhs and some, my lord, in terms of the award, my lord, I'm supposed to
Do
give.
you secure them?
Yes.
You're a statutory authority.
Yes.
Secure them.
The lordship kindly
Take instruction. Secure them.
in the month, my lord,
Don't file your affidavit of assets. Secure them. That's all right.
Instruction is over. We'll take instruction.
Take instruction. Not today.
I have served the copy, my lord.
Not today.
Copy of the execution application.
To take instruction.
Take
Okay.
If you don't want to file your asset, secure them. Mr. Sahu, you have to do something.
I completely.
Either you file your affidavit of asset and then I attach some of it,
I understand.
or you secure them. Which body is this?
Calcutta.
Court trust.
Port trust is.
The affidavits
Give
will
one of your,
have
you know,
probably 100.
boat or something, give it to them.
The entire will
No, no, only
property
bank
starting
account.
from here
Give details of your bank account.
Yes, it will.
I'll put 80 lakhs separately and then you can use your bank account.
Yes,
I'll take my instruction.
not only.
I understand that. That is fine.
Not today.
Grateful. Grateful.
Your Lordship, this is the new execution application and for the award holder. Award passed within 2 years, 29th May of 2025. Kindly give direction for affidavit and assets order.
Take down. The petitioner prays for execution of the award dated
29th May of 2025.
29/5/2025. The petition is well within the statutory period of 2 years. Full stop. Affidavit of asset to be filed by the award debtor, indicating all movable and immovable properties with an advance copy to the award holder. Full stop. Affidavit of the service to be effected upon the award debtor. Full stop. Affidavit of service shall be filed on the next returnable date. Give a date.
Award passed within 2 years. Award dated 29th May of 2025.
Same order. No? Award dated.
29th May of 2025. Yes.
These are all unilateral awards or what?
Award passed within 2 years. Award dated 24th April of 2025.
Who are the arbitrators in this? You appoint them. You appoint the arbitrators. Illegal awards.
Most of the matters will settle, Your Lordship.
That's why you're filing it. Award dated so and so.
Your Lordship, award passed within 2 years. Award dated 24th April of 2025.
Twenty-fourth April. Next.
Award passed within 2 years. Award dated 24th April of 2025.
24th of April.
Your Lordship, award passed within 2 years. Award dated 28th May of 2025.
Same order.
Your Lordship, award passed within 2 years. Award dated 28th May of 2025. Your Lordship, award passed within 2 years. Award dated 21st October of 2024. 21st October 21. Your Lordship,
Yes.
Your Lordship,
Award dated.
Your Lordship, this is not my item number.
Yours.
My lord, the award was 15.
Beyond 2 years.
15. The award was passed on May 29, 2025.
Within 2 years.
Correct, my lord.
Yes.
My lord, award of 8th September, I'm 8th August. 8th of August, my lord. Here, my lord, the money, part of the awarded sum has already been secured under section 9, which is lying with the registrar. My lord, 34 has been filed, no 36 filed. My lord, if your lordship sees, my lord, prayer D in the tabular statement, this is what I'm seeking right now. Because, my lord, this money is secured. The total awarded sum, together with interest, now comes to around 74 odd lakhs, my lord. And my lord, if your lordship takes prayer D together with, my lord, page 67, your lordship will find, my lord, that sum which is right now lying with the registrar. Page 67, if your lordship takes, my lord.
So in your section 9, the amount has been secured.
Yes, my lord. In the section 9, it was secured. My lord.
Move an application in that petition.
In the section 9?
Yeah.
My lord, in the execution, my lord, I'm seeking the award to be, the money to be.
So the money would be.
Well, lord, section 9 was pre the arbitration proceeding.
34 is pending.
34 is pending, no 36 filed.
Not right now.
My lord.
Won't give you the money.
Then I can, then I'll take out an application, well, section 9, which have by bank guarantee and.
Bank guarantee and take it. That's.
Well, should I take out an application, or can I make an oral prayer to that?
Take out an application. That's much better. Secure the money. Take out the money.
I'll do that immediately.
Give a bank guarantee. Take out that 56 lakhs which you want. That's much better.
I'll do that.
Because still your 34 is pending. I don't want to. Even if there's no 36. That's like literally.
I agree, my lord. But since there was no 36, I was take my chance. I understand, my lord. I'll immediately file an application, my lord.
This is item 16.
16.
Affidavit of asset and all is filed by them? No. This is the first time it's coming?
First time. So there is some. May there be a direction for affidavit of assets, because there is
That's
some.
much better.
Yes, my lord.
Same order. This date of award is
8th August
8th August
2025.
2025. Within
even after deducting that money, there'll still be some surplus. So therefore, affidavit of assets.
So let them file their affidavit of asset based.
I'm obliged, my lord.
You'll what's your name?
Sarvapriya Mukherjee.
So Mukherjee, give your name and number.
Lordship, this is my execution application. Lordship, this was taken up on last Thursday.
Yes.
Lordship had put a question as to the award is dated 13th May 2017. Lordship had and the last order that has been passed in the previous execution application is within 2 years. So Lordship had I had prayed that Order 21 Rule 22 notice is not likely to be served, and we can straight away pray for affidavit of assets. Lordship had asked me that the last order is that of a dismissal on default. So I have to go and file a restoration application and not file afresh. Lordship, I have two judgments. If I can place it, Lordship. One is of Supreme Court, Lordship, Bhagyodaya Cooperative Bank Limited. Lordship, this is the judgment.
So what is it? What is the
Lordship, it says paragraph 11, Lordship, page number 7. Lordship, it's
No, but your execution was dismissed, right?
it was dismissed.
Then after
Lordship, here it says that the High Court finds that that's the finding of the impugned order. 22. Oh, I gave the Lordship, it's page 17, para 21. The findings. The first question we have to consider is whether the dismissal of the
but
execution.
that was dismissed for default, right?
Yes, this was also dismissed for default. The first execution application was dismissed for default, Lordship.
You have to file a restoration.
Lordship, here in the Supreme Court, it says that the first execution question we have to consider is whether the dismissal of the execution petition filed by the appellant apparently on the ground of default or withdrawal of the first execution petition will result in a bar for the filing of the prosecuting of the second execution petition. In this regard, in fact, we must notice that the learned counsel for the respondent does not seek or raise any objection as such to the contention of the appellant that the second execution application would be maintainable provided it is within the period of limitation. We also find merit in the contention of the appellant.
Where are you reading, madam?
Lordship, it's page 17, para 21.
What about the findings of the impugned order, page 11?
Lordship,
Para 11. You said para 11, right?
Lordship, that is the impugned order that has been given by the High Court.
All right. Which
Supreme
page?
Court's finding is at para 21, para 17, page 17.
Page 17.
Lordship, the para 21.
Yes.
The first question we have to consider is whether the dismissal of the execution petition filed by the appellant apparently on the ground of default or withdrawal of the first execution petition will result in a bar for the filing or the prosecuting of the second execution petition. In this regard, in fact, we must notice that the learned counsel for the respondent does not seek to raise any objection as such to the contention of the appellant that the second execution application would be maintainable provided it is within the period of limitation. We also find merit in the contentions of the appellant that the mere dismissal of the first application on the ground of default may not result in the decree holder being precluded from filing a fresh execution petition provided it is within time. Lordship, this is within the time of 12 years. So, Lordship, and there is another judgment of Calcutta High Court which covers this judgment also. Lordship, if I could place this. Give me a copy.
Yes.
How do I place it? Lordship, give me 1 second.
Yes.
Lordship, this is page 3 of the judgment. 1, 2, 3, 4, fifth paragraph. With regard to the first objection. Lordship has found it.
Yes.
With regard to the first objection as to the maintainability of this application, in view of the dismissal of the prior execution case, the award debtor is justified in arguing that the award holder could have done well to point out before this court in the tabular statement as well as in affirmance in the application that the previous execution petition was not withdrawn with or without liberty to file afresh but was dismissed for default. Such omission error on the part of the award holder is strongly deprecated. However, such such error on the part of the award holder cannot be elevated to such an extent that it would be deemed to be intended to deliberately mislead the court, for the simple reason that the award holder has also annexed a server copy of the previous order of dismissal in the execution petition. From the said order of 11 November 2019, it transpired that none appeared in either of the parties when the previous execution case bearing so-and-so was dismissed for default. The provisions of Rule 105 and 106 of Order 21 of the Code of Civil Procedure are nowhere couched in negative language so as to preclude the award holder or decree holder from filing a fresh execution case on the self-same cause of action in case of dismissal for default. Unlike Order 9, there is no such specific bar in Order 21 in respect of an execution case. It is also to be noted that even in Rule 4 of Order 9, in cases where none of the parties were present at the time of the call and the suit was dismissed for default, there is no bar on the plaintiff to bring a fresh suit on the self-same cause of action, even if the previous suit was dismissed for default. Applying such principle in any event, there is no bar even in the Code of Civil Procedure to prefer a second execution case in such circumstances as in the present case none of the parties were represented when the dismissal for default occurred. Then the Supreme Court judgment is taken into account. That apart, this court is bound by the proposition laid down in Bhagodaya, where the Supreme Court in unambiguous terms accepted the contention of the appellant herein that mere dismissal of the first execution application on the ground of default may not result in the award holder or decree holder being precluded from filing a fresh execution petition, provided it is within time. So, Lordship, here I was praying that an affidavit of assets direction may be passed.
Take down. The petitioner is seeking execution of the award dated 13/5/2017. Full stop. The execution petition has been filed beyond the statutory period of 2 years. The department is directed to effect service upon the award debtor in terms of Order 21, Rule 22(1) of the Civil Procedure Code, 1908. The department shall file a report within the next returnable date. Full stop. List the matter on such and such. इसमें एक line और add करता हूँ. Learned counsel को the petitioner has pointed out there was an execution petition which was filed earlier. Execution petition number
EC 563 of 2018,
EC 563 of 2018,
which was
was dismissed for default on
8th August 2025.
8th August 2025. Full stop. She has relied on the judgment of this court in EC 8 of 2022, title so and so, ye kar dena, dated so and so, and on the judgment of the Apex Court, so and so, so and so. Okay. Reading of both the judgments would indicate that the filing of the second execution petition is not barred in case the first is dismissed for default. In view of the same, the present execution petition has been filed. बस 2 line डाल दें. 8 weeks. ये उसमें एक मिनट सुनना. In view of the same, the present application is maintainable. After lunch.
After lunch, sir. As far as item 72 is concerned, my execution, there's section 47. Some documents had inadvertently not been included. I made a supplementary affidavit, I've served them. May I have leave to file it? Your Lordship takes it up next Thursday, whichever.
My lord, today I've received the supplementary, my lord.
I'm not asking for leave to file. Certain documents only have been annexed to the supplementary.
So I have to see the file. Let me come back.
No, your Lordship doesn't take these after lunch. That's why I took the indulgence.
No, I do.
My lord, execution matters
कितने बजे?
It's item 72. I was told.
72.
I've served them. I can file it on the next day when your lordship takes up the matter.
You have served them?
Only I have not taken my lord's leave, so I said it's imperative we should have taken it. We served it this morning, but we should
We'll
have.
take it on record next date. You have served it, right?
My lord, I have received today, my lord.
The next Thursday.
Next Thursday, I won't be there after 2 weeks.
My lord.
Then we have some precedence. The section 34 is stalled in Malajkand, Jabbalpur.
We'll see.
2 weeks.
Item number 31 to 30.
And my lord will keep it day after 2 weeks. My lord, I'll file it. My lord.
You file it after 2 weeks. I'll keep it on record.
That's the item number 34 to 33.
Which is after today's list. There has been settlement between the parties. Kindly withdraw the matter. And
Take
that is
item
the
390.
Item number 390. 390.
Just take 390.
Item number 390. Today's list.
390.
That's the item 31 to 33 is beyond 2 years. I'm only praying for
In
service.
today's list.
390. Learned counsel for the petitioner states that the matter has been amicably settled.
390. 292 of 2025.
Has been amicably settled between the parties. She wishes to withdraw the present petition. The same is dismissed as withdrawn. Interim orders, if any, stands vacated. Dismissed as withdrawn, 390. It's noted down. Yes,
Item 31 to 33 is beyond 2 years. So I'm praying for the department service, Lordship.
wait.
Lordship,
Yes.
item 52, Lordship, Lordship is not rising, Lordship, but urgent circumstances, the appeal was dismissed 1 year back, 34 dismissed. I'm only praying for, the appeal has been dismissed 1 year back, there is
We'll
nothing.
see that. Let me come back from the circuit. We'll see.
Lordship,
क्या है? हाँ, सरेंडर है। हेलो।
একটা মেনশন করবো ওজন করা যাবে তো with regard to item 444 Lord, in this matter under the heading examination of judgment debtor, so the Mrs. Shatabdi Banerjee Datto, she is appearing for judgment debtor number 1. Lord, on 24th February, she met with an accident, severe accident. She was driving the scooty, car dashed her, fell down, and got severe injury all over the body, and also broke her 3 of his fingers, leg fingers. So, in this situation, she has been advised for rest at least for more than 1 month. So, would it be your lordship's pleasure to adjourn this matter? Because in this situation,
Which item
my
is
landed friend is happy. I'm not in this matter. I have been requested to.
It's not coming up right now. Why are you mentioning it? When it will come up, you make the submission.
At the time of call.
Yes.
Then my landed friend is here. He will ask for pray for time.
All
I'm grateful to you.
Yes. Who's there to give the oath? Who's there to give the oath to him? You give it. आप दे दो.
हिंदी हिंदी
जो बोलूंगा सच बोलूंगा सच बोलूंगा अजित कुमार क्या नाम अजित कुमार उम्र 28 पिता का नाम चंद्रिका राय चंद्रिका राय ये इंडिया राय आर्यवान एड्रेस गौर मिर्जापुर बादाम तला अलमारी का गौर मिर्जापुर बादाम तला हमारी कारखाना मासीला सकराई बादाम तला मासीला सकराई हावड़ा 711302 क्या करते हैं प्रोफेशन क्या है क्या काम करते हैं ट्रांसपोर्ट के काम करते हैं ट्रांसपोर्ट का काम क्या ड्राइविंग नहीं काम दुख से देख रहे करते कार पे करते ट्रांसपोर्ट का डॉक्यूमेंट দুজন আছে से जो फाइल करना वो हुए और जब ओटीपी आने के तब आए और जो दस्तखत कागज जो फाइल करना है उसको देखो तो साथ फाइल कर ठीक है वेबसाइट जैसे ऑर्डर करें ठीक है जजमेंट में तो 1 शीट हाँ जो बोलूंगा सच बोलूंगा बात के बिना झूठ नहीं
जो बोलूंगा सच के बिना कुछ नहीं बोलूंगा राजीव कुमार राय
अरे भाई
अरे भाई 45
45 पिता का नाम
चंद्रिका राय
चंद्रिका राय एड्रेस
वेदांतला मसिला
काम क्या करते हैं
ड्राइवरिंग
ड्राइविंग प्रोफेशन ड्राइविंग जैसे जैसे ऑर्डर करेंगे जो बोलेंगे कागज देना है जमा करना है हम करेंगे और जॉब जिस दिन में फिर आने के लिए बोलेंगे ऑर्डर करेंगे उस दिन आ जाए ठीक है
Where's the vehicle?
hardship
Where's the
We
vehicle?
have taken possession of the vehicle, my lord.
You've taken
Lord,
possession.
we are in possession of the vehicle.
Undisputed, my lord. All that I'm praying for, my lord, is some time to file my affidavit of, my lord, assets. And my lord, Wakalatnama has also not been filed.
Then ask them to make the necessary payment. How much is the due?
Due is of 21 lakhs.
And we'll take instructions to that effect, my lord. Not instructed. Kindly grant us leave to, my lord, file the affidavit of assets and, my lord, file the Wakalatnama in the department.
Take down. While order dated 29 January 2026, this court had issued warrant of arrest against award dated number 1 and 2. Full stop. Award dated number 1 and 2 have surrendered before this court. Full stop. Oath has been administered. The warrant of arrest is discharged. Full stop. Award dated number 1 and 2 seeks and is granted. States that they shall file their affidavit of asset and will remain present in the court as and when required. Full stop. The learned counsel for the award dated number 1 and 2 seeks and is granted 2 weeks time to file. 4 weeks is too long. 3 weeks time to file his affidavit of assets, including all movable and immovable assets, with an advance copy to the learned counsel for the award holder. Let this matter be listed on, give a date. After 6.
6 weeks. Grateful, Lordship.
Okay.
My lord, appearing for the award holder. He's appearing.
Yes, madam. Is here. Come on the stand. जो सवाल पूछे वो बताइएगा.
जी सर.
Oath तो नहीं बनता. Oath नहीं बनता.
বাংলা
যা বলবো
যা
সত্য
বলবো
বলবো
সত্য বলবো
সত্য ছাড়া
কোনো মিথ্যা বলবো
কোনো মিথ্যা বলবো
না.
এবার আপনার নাম বলুন
চিরঞ্জিত মাইতি.
চিরঞ্জিত
মাইতি.
বাবার নাম
বিকাশ মাইতি. বিকাশ মাইতি.
বিকাশ মাই
হুম।
এজ
31
এজ 31 অ্যাড্রেস
মহরমপুর বগুড়ান দেশদত্ত পোস্ট দেশদত্তবাড়.
আস্তে আস্তে আই কার্ড আছে
ওইখানে ফাইলে
আস্তে বলবো বহরমপুর
বগুড়ান পোস্ট দেশদত্তবাড়.
বহরমপুর বগুড়া পোস্ট
দেশদত্তবাড়. দেশদত্তবাড়.
এস দত্তবার
হ্যাঁ. ডিস্ট্রিক্ট পূর্ব মেদিনীপুর.
ডিস্ট্রিক্ট পূর্ব মেদিনীপুর
পুলিশ স্টেশন কন্টাই.
এস কোনটাই
হুম
পিনকোড
721450 1450
121450 দশের যা ফাইল করতে বলবেন সেগুলো করবেন, যা যা অর্ডার করবেন সে অনুযায়ী আপনার করতে হবে। এখন
স্টার্ট করবো?
করবেন
হ্যাঁ। Under whose instructions this affidavit of assets has been prepared? Acha. Under whose instructions this affidavit of assets has been prepared?
English, Bengali, what?
বেঙ্গলি
অ্যাফিডেভিট অফ অ্যাসেট যেটা ফাইল করেছেন কার ইনস্ট্রাকশনে ফাইল করেছেন?
মানে
আপনি একটা অ্যাসেট ফাইল করেছেন, ফাইল অ্যাফিডেভিট অফ অ্যাসেট আপনি ফাইল করেছেন, এটা আপনার যা সম্পত্তি আছে সেটার একটা অ্যাফিডেভিট করে আপনি
Affidavit of
আপনার কাছে আপনি ফাইল করেছেন।
হ্যাঁ
কে করেছেন, কার ইনস্ট্রাকশনে?
লাস্ট জজ সাহেব বলেছিলেন না কি কি আছে না আছে দিতে বলছিলেন, তো আমার তো কিছু নেই, যা যাচ্ছে।
বাই অর্ডার অফ দ্য অনারেবল জাজ।
Are the statements made in the affidavit of assets true and correct?
যা যা ওখানে যা যা সম্পত্তি দাখিলা করেছেন
হুম
সেগুলো সব ঠিকঠাক?
হ্যাঁ সত্যি সত্যি কোনো মিথ্যে নেই, সত্যি।
All the statements made in the affidavit of assets are true and correct.
Mr. Maiti, are you aware of the present execution proceedings?
যে কেসটা হচ্ছে সেই ব্যাপারে আপনার নলেজ আছে তো, জানেন তো?
হ্যাঁ হ্যাঁ হ্যাঁ
Yes.
Please tell this court as to when did you avail the loan facilities from Tata Capital Limited?
মহামান্য বিচারপতিকে বলুন যে টাটা ক্যাপিটালের থেকে আপনি কবে লোন নিয়েছিলেন?
আমি টাটা ক্যাপিটাল থেকে লোন নিয়েছিলাম 2020-তে জানুয়ারি মাসে নিয়েছিলাম।
এবার বলুন।
2020-তে জানুয়ারি মাসে নিয়েছিলাম।
2020
জানুয়ারি
The loan
2020
was granted. মানে আপনি লোনটা পেয়েছেন কবে?
জানুয়ারিতে 2020।
2020.
What was the purpose of availing such loan facility? And the amount that was sanctioned to you?
যে টাকাটা আপনাকে দেওয়া হয়েছিল লোন হিসাবে কি উদ্দেশ্যে নিয়েছিল?
ও গাড়ি কেনা, একটা জেসি মানে ওই যে হুন্ডাই একটা গাড়ি কেনার উদ্দেশ্যে।
পারচেজ ওয়ান
গাড়ি কেনার।
কি ধরনের?
ওই মেশিন যে মাটি খোঁড়ার যে মেশিন গুলো, জেসিবি টাইপের মতো।
ওয়ান সয়েল এক্সকাভেটর মেশিন।
পকল্যান্ড এরকম।
Is this true and correct that you availed such loan facilities for purchasing one excavator?
এক্সকাভেটর।
আরেকবার বলুন।
Is it true and correct that the loan facilities was availed for purchasing the excavator?
লোনটা যে নিয়েছিলেন মেশিন কেনার জন্যই নিয়েছিলেন,
হ্যাঁ
সেটা সত্যি না মিথ্যে?
হ্যাঁ সত্যি।
Is it true that the said excavator was hypothecated with Tata Capital Limited for repayment of its loan?
হাইপোথিকেট করা ছিল টাটা ক্যাপিটালের কাছে, লোনটা শোধ না করা পর্যন্ত ওটা বন্ধক করা ছিল টাটা ক্যাপিটালের কাছে।
অ্যাকচুয়ালি
মেশিনটা
মেশিনটাকে আমি কিনতে পারিনি, মানে ওটা একটা পুরোনো মেশিন ছিল। টাটা ক্যাপিটাল আমাকে বলেছিল যে বেশি টাকা লোনের পরিমাণটা বেশি দেবে। লোনের পরিমাণ 19 থেকে 20 লাখ, যখন আমি লোনের জন্য অ্যাপ্লাই করেছিলাম 19 থেকে 20 লাখ টাকা দেবে বলছিলেন। সেইখানের জন্য আমি একটা পুরনো একজন লোকের কাছ থেকে পুরনো মেশিন কিনতে গিয়েছিলাম। তারপরে টাটা ক্যাপিটাল ওই পুরনো মেশিনের উপরে রিভ্যালুয়েশন করে আমাকে সে লোন দেয় মাত্র 12 লাখ টাকা, 12,28,000 সামথিং লোন দেয়। তো যা লোন দিয়েছে ওই টাকাটা আমি যার কাছ থেকে মেশিন কেনা হবে ওনাকে আমি সম্পূর্ণ টাকাটা আমি দিয়ে দিই, যে টাকা আমি লোন পেয়েছি সেই টাকা লোন দিয়ে দিই। তো পরে টাটা ক্যাপিটাল আর লোন মানে অ্যামাউন্ট আর না দিতে পারাতে আমি ওনাকে আর পয়সাও দিতে পারিনি, আর সেখান থেকে আমি মেশিনটাও তুলে নিয়ে আসতে পারিনি। তারপর মেশিন সেই ওনারের কাছেই থেকে গেছে, আর ওনারকে ফোন মানে চাইলেও দিচ্ছে না।
আপনাকে জিজ্ঞেস করছি
একটু
আপনি
slowly বলতে বলুন।
বন্ধক করা ছিল না ছিল না?
বন্ধ মানে আমি
বন্ধ ছিল। আচ্ছা, আপনার উনি আরেকবার বলুন।
একটু বুঝিয়ে বলুন ওনাকে।
আচ্ছা
ধীরে বলুন।
সরি। ঠিক আছে, মানে আমাকে টাটা ক্যাপিটাল বলেছিল যে 19 থেকে 20 লাখ টাকা মতো লোন স্যাংশন করে দেবে বলে, যিনি ফাইলটা প্রসেস করেছিলেন।
There was a verbal agreement that Tata Capital will sanction 19 to 20 lakh for purchase of one soil excavator machine.
ঠিক, হ্যাঁ
Right?
হ্যাঁ,
তারপর
কিন্তু পরে পরে সেটা আমাকে লোন স্যাংশন করে টাটা ক্যাপিটাল দিল 12,28,000।
But later on, Tata Capital sanctioned only rupees 12 lakh
28,000
12 lakh 28,000. আচ্ছা, then
যেই টাকাটা আমাকে দিয়েছিল টাটা ক্যাপিটাল, আমি সম্পূর্ণ টাকা যার কাছ থেকে পুরোনো মেশিন কিনবো তাকে আমি দিয়ে দিই।
I paid the whole amount to a person for purchase of one old machine.
হুম।
তারপর
তারপর টাটা ক্যাপিটাল আর আমাকে কিন্তু লোনটা আর বেশি বাড়িয়ে না দিতে, আমি ওনাকে টাকাটা দিয়ে দিতে টাকাটার পরিমাণ কম হয়ে গেছে। ওনার মেশিনের মূল্য ছিল 21,50,000 টাকা।
actual cost of the old machine was 21 lakhs, but Tata Capital did not grant any further sum. দিল না।
না,
তারপর
তো সেই জন্য আমি ওনার কাছ থেকে গাড়িটিও নিতে পারলাম না।
for that purpose I could not get the car, that machine from that person. ওই লোকটার নাম বললেন না?
কৃষ্ণ বাহাদুর প্রধান,
Person namely
কৃষ্ণা ট্রান্সপোর্ট।
Krishna Trust. From that person or from that company. তারপর
ওনাকে চেকের মাধ্যমে দিয়েছিলাম 10,35,000।
I paid 10,35,000 by check
আর ক্যাশ দিয়েছিলাম 1,75,000 টাকা ক্যাশ দিয়েছিলাম।
and paid cash to the sum of rupees
75,000।
1,75,000.
Is it true and correct? Is it true and correct that you availed a sum of rupees 12,75,000 and thereafter failed to repay the outstanding amount to Tata Capital Limited?
আপনি 12,75,000 টাকা লোন নিয়েছিলেন, সেই টাকাটা আপনি টাটা ক্যাপিটালকে ফেরত দিতে পারেননি, এটা সত্যি না মিথ্যে?
হ্যাঁ, টাটা ক্যাপিটালকে ফেরত দিতেই পারিনি, যে গাড়ি ওনার কাছ থেকে আমি নিতে পারিনি আর গাড়ি চালাতেই পারিনি, সেই জন্য টাটা ক্যাপিটালকে আমি ফেরত দিতে পারি। টাটা ক্যাপিটাল, হ্যাঁ সরি গাড়িটা
আগে বলুন আপনি দিতে, উনি জিজ্ঞেস করছেন যে আপনি টাটা ক্যাপিটাল থেকে যে লোন নিয়েছিলেন সেটাকে আপনি ফেরত দিতে
Just
পেরেছেন
make,
না পারেন?
just speak one line. Did you pay off the loan? वापस just ask him if he paid off
লোনটা
the loan.
আপনি শোধ করতে পেরেছিলেন না পারেন?
না, লোন আমার কাছ থেকে 4টে না 5টে ইএমআই কাটার পর থেকে আর শোধ করতে পারিনি আমি।
I paid only 4 to 5 EMI the same loan.
I suggest to you that the hypothecated asset, being an excavator, is lying in your possession and you are enjoying it.
আপনার কাছে ওই মেশিনটা রয়েছে আর আপনি ওটা ব্যবহার করছেন, এটা সত্যি না মিথ্যে?
না, এটা মিথ্যে।
Can you suggest where is the hypothecated asset lying currently?
কোথায় মেশিনটা আছে বলতে পারবেন?
ওই দুর্গাপুরে আছে মেশিনটা।
মেশিন লাইং ইন দুর্গাপুর।
কৃষ্ণা ট্রান্সপোর্ট।
লাইং ইন with Krishna Transport,
দুর্গাপুর।
I suggest to you that you have sold the said hypothecated asset to third party and created third party interest.
আপনি মেশিনটা অন্য কোনো নিয়ে আপনি অন্য কাউকে বিক্রি করে দিয়েছেন?
না না, আমি মেশিনটা ওনার কাছে নিতেই পারিনি টোটাল।
No, I could not get the machine from him at all.
According to him, he has never bought the machine.
Lordship.
According to me, he has siphoned off the money.
Like Lordship, this is not concerning us because he has already availed such loan facility pursuant to which he has defaulted in making repayments.
That's right.
But Lordship, with regards to the hypothecated asset, I need to come back with instructions as to what is the current status with the company, if the hypothecated asset is still with the company or it has been with the award debtor. Since he is deposing that he has never availed such a hypothecated asset, so what asset is being lying with the company before which we are claiming? So we need to come back with instructions to know.
Should know where the excavator is.
We have to come back with instructions.
Yes.
Receipt has been issued by the vendor lying with the
That is, since Lordship, that is the only security we have in order to proceed further. So if you have not received anything, so we need to ask the company itself if any security is lying with them in order to proceed further.
Anything else? The examination is further deferred. Examination is further deferred for. Just give a date.
For his working purpose, he is staying at Bangalore as a.
So tell him to give the money, or he should go to jail, spend 3 months there.
Yes, that's. But Lordship,
Tell him to give the money.
Yes.
If he has not taken the vehicle, tell him to get the money, pay it off.
Yes.
Finish it off. Whether he's working in Bangalore, whether he's working anywhere, we are not concerned. He'll be here in the courts.
He's trying to contact the vendor.
It doesn't, madam. It doesn't matter. It's been 2020. We are sitting in 2026. So don't give me all that. He's trying to contact. He has no intention of paying any money. And he shall remain present whenever the court calls him. 3 months. On his dictate, we'll decide the dates. Huh? Keep it after 4 weeks. Give a date on 4. He shall remain present on. Give a date. Give a date. 9th April.
Grateful, Lordship.
Tell him to make the payment or stay here only.
Working there as a picker.
Doesn't matter, madam. Doesn't matter. He's just avoiding making payment.
Sir,
He has done nothing. He's just siphoned off the money.
আমি কি করি ডেলিভারি বয়
9th April को आप रहेंगे यहाँ
9 अप्रैल को सर एक
या तो पैसा दे दें बाकी आपका कोई रिक्वेस्ट नहीं सुन रहा हूँ मैं मेक द पेमेंट नेक्स्ट
Your Lordship, in this matter, I am for the award holder, Your Lordship.
Where is he?
My Lordship, my client cannot appear before this honorable court, my Lordship, because he is suffering through the inflammatory disease, my Lordship. Here is the report, my Lordship, along with the pictures. Already, my Lordship, 1 month has been passed. Doctor has advised to take bed rest for 2 months, my Lordship. I am on this for 1 month's accommodation, my Lordship.
All these private, these things doesn't impress me.
No, my Lordship, he is advised on this, my Lordship. To any inflammation, he cannot stand on its own, my Lordship.
Judgment data number 1. He's number 1. Judgment data number 1 is not present in the court.
Your Lordship.
Despite specific directions to remain present for examination. Full stop. Learned counsel for the judgment debtor has handed over some loose papers which are said to be medical record indicating that the judgment debtor is suffering from inflammation. Full stop. Though this court is not in a position to take a call on the since the judgment debtor prays that he is unwell, let this matter be listed after 4 weeks for examination.
Your Lordship, only indulgence is asked, Your Lordship. By the order dated 11 December 2025, Your Lordship, the judgment debtor number 2 is directed to be present for examination, but till date, no affidavit of assets of judgment debtor number 2 has been filed, Your Lordship. Only the judgment debtor number 1 has filed the affidavit of assets, Your
You
Lordship.
appear for 2 also?
No, my lord, I am for judgment.
Who's 2?
Your Lordship, most probably his wife, the judgment debtor number 2 is the wife of judgment debtor number 1, Your Lordship.
It's your own wife? What do you mean not?
Sir, I have to take instruction. I have
Take instruction.
to-
Husband, wife will have different lawyers.
My lordship, I am only appointed for judgment debtor number 1.
Don't play all this drama here, please. Huh?
I have to take instruction. my lordship.
Foreign matter to same matter. Let the matter be called once.
32. My lordship,
And make sure the affidavit is filed.
Yes, yes, my lordship. I will take instruction and I will inform my lordship.
And you think we don't understand?
No, my lordship.
Husband, wife playing a game, we don't understand.
Actually, my lordship, my senior is supposed to engage in the matter, my lordship. I have to only take instruction. Now, 432.
Same matter, Your Lordship, between the same person, Your Lordship.
Same order.
Grateful, Your Lordship.
4 weeks.
Three.
But I appear on behalf of the award holder.
On last particular directly submitted some of the documents, not been able to collect all the documents, certificate copies is unable to obtain. We don't have the funds as I have instructions for it, but some documents we are able to obtain with regard to some orders and all the same notices we are able to obtain from it advocate that I can submit before the honorable court but with regard to the
Lord, I apologize when I'm saying this, my lord. The undertaking was to give the PAN card. What
Where's the PAN
difficult?
card?
that is the notice, same notice and all the documents with regard to some of the orders we are able to obtain.
Lord, these are the cost people.
We are talking about a PAN card, madam.
PAN card, Lord.
With the cost papers, he has not
He's proceeding. He has filed.
obtained, the cost papers, doing some orders and sale notices he has been able to, what was which he has able to collect, with regard to other cost papers.
I'll send him to jail for a few days. He'll collect everything, madam.
That's why he has not been able to collect, if your lordship,
If this is the conduct,
what I have instructed.
madam, we don't go by the instruction. Where are you? Yes. Why you're not giving the documents? Yes. Why you're not complying with the orders of the court? Who's there in this matter? Which one of you? Both of you. Why you're not complying with the order of the court? Why you're not giving all the documents?
বাংলাতেই বলছি যা যা ডকুমেন্ট ছিল সব আমি দিয়েছি ওর ভিতরে প্যান কার্ড সব আছে
Just see what documents you want and
Lord, I'm sorry, my lord. If my lord kindly take question number 10 and 11.
His PAN card is there, my lord.
And my request was to find a copy of the PAN card be made available to us so we can take steps accordingly and conclude.
The PAN card is there, my lord. We can do with that.
You know the object.
My lord, other
Out of Dash.
cross examination dekha na?
You know, and these are cost papers. May I hand over my copy till such time? No, my application.
Where's the examination?
Kindly see your series question numbers 10 to 13.
Only till 4. Where are the other?
Witnesses नाम সৌরভ দাস, interpreted by সুকান্ত দাস।
না
হয়েছে 29 জানুয়ারি 2026।
Yes. Which questions?
Now we'll kindly take
10.
10 to 13, my lord.
Yes. He's giving you the PAN card.
PAN card is given.
Lord, kindly see my. Do you have a PAN card? Does the judgment letter have?
That's what he's saying. The PAN card is giving.
PAN card is
Cost
given, but the
Give the PAN card.
And SS Enterprises is PAN card? Or SS Enterprises is PAN card?
পুরোটা লিখে নিলে আমি আপনাকে original দেখি।
Certified?
11 number पे है।
अच्छा। तो वापस आ
And
जाना।
cost papers?
Cost papers. With regard to that, my lord, I can give my lord the sales certificate and all the some of the orders, my lord. He has obtained that.
মানে এই এসেটা তো আপনারা ফাইল করেছেন।
কি করব? বলছেন সার্টিফাইড কপি দরকার। সার্টিফাইড কপি the cost.
আপনাদের কি সার্চ করেনি?
We have, but probably don't have. It doesn't have those papers, my lord.
এটা কেন করলো? শেষ করে দিতাম না আজকে।
Yes.
Lord, may I come back and finish the examination?
Do it now. He's here.
Lord, my intention was to take this PAN card, assess the number on the basis of the websites to ascertain whether he has assets or not, do a search. That is why I specifically sought if it could be produced before the date fixed for examination, so that I could have finished the undertaking today. I am being handed the same over here.
Your examination is only confined to the PAN card now.
Lord, his PAN card and the enterprise that he belonged to, the
Correct.
PAN card of the enterprise. And my lord, I had also had reasons to believe that in these RFC application that I had sought for the cost papers, there are other properties that have been described there that have not been brought on record here. These are the only 3 reasons I had asked these questions.
Where is the document for this essay number 373 of 2023 and essay 280?
The order copy, my lord, and the same notice, my lord.
Give the order copy of this.
I have received it here and now, my lord, I have received. That is why I am seeking if my lord could keep it on Thursday next, I will come and control.
This will only happen after I come back then. Very long. Award dated number 1 and 2, right? These are 1 and 2. 2 of them are there?
Yes, the both of them are.
Award dated number 1 and 2 are present. 2 and
No,
3.
2 and 3, my lord. I'm sorry.
2 and 3 are present. They have handed over a copy of the PAN card, personal PAN card, as well as the PAN card of the SNS Enterprise. Full stop. Some documents relating to essay number 373 of 2023 and essay number 280 of 2023 has also been handed over to the award holder, counsel for the award holder. Full stop. Learned counsel for the award holder states that he shall examine the award debtors after doing his due diligence on the basis of the PAN card if the award debtors have any assets, any other assets apart from the ones indicated in the affidavit. Full stop. He prays for an adjournment. Let this matter be listed for examination on, give a date, examination of the award debtor number 2 and 3 on after 5 weeks. Which date? 16th. 16th April. Give it back to him.
We can go against these properties. Not USH.
34.
In this matter, I am for the award holder, Your Lordship.
Who's appearing for the award data? They're appearing?
Your Lordship, on the 15th January, he was produced. The judgment letter number 1 was produced on warrant. Thereafter, they have filed, the judgment letter number 1 has filed the affidavit of assets, Your Lordship.
They have filed it?
They have only the judgment letter number 1, Your Lordship. And judgment letter number 1 is also only present before Your Lordship.
Is here today?
Not today, Your Lordship. I don't think.
Not today.
I'm-
Let it be not today.
Not today. Great. 4:30, 4:30. Your Lordship, in this matter, I am for the award holder, Your Lordship. In this matter, Your Lordship, 8th October 2024, the warrant of arrest was issued, and subsequently, by an order dated 29 January 2026, the same was extended. Till date, no report, neither he has been produced nor any report is, Your Lordship.
He has been absconding.
He has been absconding. What about the? No. Judgment letter number 2 to acha. Your Lordship, the judgment letter number 2 has not yet filed the affidavit of assets, though there is an order with that regard.
Is the wife?
Not sure, Your Lordship. Yes, Your Lordship. Most probably is the wife of judgment letter number 1, Your Lordship. Lordship may extend the warrant, Your Lordship. It's absconding all.
Take down. This court by order dated 8th October 2024 had issued warrant of arrest against the award letter number 1. The same has still not been executed. Full stop. The warrant of arrest is further extended for a period of 8 weeks. The officer in charge / inspector in charge of the concerned police station, as well as the superintendent of police having territorial jurisdiction over the said area, are directed to ensure the due execution and implementation of the said warrant in accordance with law. This matter, after 8 weeks, Deputy Sheriff shall file a report on the next date. Non-commercial है? Your which matter? 436.
Non-commercial matter.
Non-commercial.
Matter number 1.
This is for withdrawal at come at my instance. The petitioners do not wish to proceed with the execution. One of them is very aged and the other is the son. I've got written instructions, my lord.
Mr. Ali is happy.
No submission. If they are withdrawing, more than happy. Their execution happy.
Learned counsel for the petition seeks.
Actually paid them off substantially, but whatever they're withdrawing.
Learned counsel for the petitioner seeks to withdraw the present petition. Same is dismissed as withdrawn.
But I consider always myself as an officer of court, so I think I've also come to know very recently. That's why I'm telling you, Lordship, the petitioner number 1, all our family members, but he has died. His name has not been struck off yet. That much I can tell you, Lordship. I don't think they will have any objection, but we have told the other coordinate bench number of times, but the judge said very well, we'll look into it.
Application, I believe, is pending for substitution or strike.
Your Lordship can allow that also, and
That is one thing I would like to record, that the award stands satisfied.
that is, I only have instruction of withdrawing. Your Lordship can record that so that there is no confusion.
Without any
The petitioner number 1 is already done.
Petition number 1
Is dead.
Deceased.
Deceased, my lord. And
a
all the other petitioners have given consent to
substitution
withdraw.
application has already been filed. Though since the
It's already in the
petitioner
list
seeks to withdraw the present petition, no order needs to be passed on the substitution
lord.
application. The present petition as well as all pending applications stands dismissed as withdrawn.
So deeply.
Full stop.
Kindly don't.
interim order, sir.
The
all
interim
interim orders
order,
are-
if any, stands
There's no interim order, but your Lordship, my Lordship can want that, your Lordship can record.
vacated.
Item number 2, my lord. Mr. Meghnad Datta appear in this matter, my lord. He is coming, my lord. Kindly short passover, my lord.
Passover at this time, 3:30 is there.
He is engaged with
Any other date? Not today. Not today. This is execution, sir. You are appearing for the judgment letter. File your affidavit of asset. You have already filed.
Yes, my lord. Examination is going on, my lord.
Examination.
Yes, my lord.
Got the document last.
Yes, my lord.
Not today.
For the award owner, decree holder. We are not appearing for last more than a month.
Settlement code,
They said last occasion that we will settle the matter. And Lordship's order was there to inform the arrest warrant there, the local police station. That also did not come into any effect.
He had appeared last time.
Yes, they appeared last time, and thereafter they told us they will settle the matter, but nothing has happened. And they given a letter up to that extent also, requesting them to comply with my lord's order. এটা আমরা চিঠি কমিউনিকেট করেছি সেটা ফর কমপ্লায়েন্স অফ দ্য কোর্টস অর্ডার। ঠিক আছে, দিন আমি বলি তারপরে আপনাকে। হ্যাঁ, এটা বেটার হবে, এফিডেভিট করে দেওয়াটা বেটার।
Something বাকি দিন আমাদের জিজ্ঞেস করেছে।
More than 66 lakh.
Warrant of arrest issued against the two directors, namely Rana Bhadra and Mr. Jagannath Debnath, while order dated 25th July 2025 has still not been executed. Full stop. The warrant of arrest, the concerned police station as well as the superintendent of the concerned jurisdiction shall ensure the execution of the warrant of arrest issued by this court by order dated 25th July 2025. Deputy Sheriff shall file a report on the next date. List on. Give after 6 weeks. That's the only way.
I think we are avoiding the court process.
Let's see, we'll.
I can recall application.
And also file one application before your lordship for recalling of the warrant of arrest. But they have not moved it. They just filed.
Dismiss করে দিক সেটা তাহলে।
Kindly dismiss that application also. Possible GA3 possible.
We'll see that, sir.
Very good. I'm grateful to you, Lord.
Item 4, you're there?
Sorry.
Item 4.
Lordship, on the last occasion, the respondents were directed to file their affidavit of assets and liabilities. They have filed it. We have received the same on 6th March. Kindly fixes the next date for the examination of the judgment.
So only award letter number 2 has filed it?
Yes.
Affidavit of assets. You have got a copy of that?
We have received the copy.
हमारे पास है? नहीं? We don't have a copy. They must have given you advance copy.
They must have. They were here on the last date, but today I can't see them.
We'll keep it after, not today. You're there? Yes. Where's the affidavit of asset? You have not given it to the court. Affidavit of asset is taken on record. The award letter number 2 shall remain present for examination on the next date. Give a date. Affidavit of asset as well as the wakalatnama is taken on record. List for examination of award letter number 2. Give a date.
6 weeks.
6th April.
6 weeks.
6 weeks. After 6 weeks.
Good.
The power to appear, but I was instructed to appear and.
Award letter.
Yes, ma'am.
Wait.
Seek 1 week time to file the wakalatnama thereafter.
Your Lordship, on the 9th February, the judgment letter number 1 was produced on warrant, Your Lordship, and on oath they have submitted that they have to file their affidavit of assets, Your Lordship.
All right. Learned counsel for the respondent. Award letter states that it's a change brief. He seeks and is granted 2 weeks time to file his further time of 2 weeks to file his affidavit of asset as well as the wakalatnama. List after.
Great.
वो तो एग्जीक्यूट हो गया था है ना 12 को हो गया था
Grateful.
List after 6 weeks.
The Lordship, any specific date can be
After 6 weeks, give it.
20. Grateful.
This is my execution. But, in terms of audit 21 and Rule 22, it's been award which has been passed within 2 years. So we have not served, my lord. Only, my lord, I would like to point out two defects, my lord. My lord, instead of making the Union of India party, the Eastern Railways has been made a party. My lord, lordship will kindly grant me leave to correct it. It will accordingly will have to be reflected. The contract was with Union of India. Eastern Railways was the executing body.
So you make both of them party?
I'll add them, my lord. Lordship kindly grants me the liberty, my lord, I'll take names.
Learned counsel for the award holder states that prays for liberty to add Union of India as a necessary party to the present execution proceedings. Liberty is granted since the contract was executed with Union of India.
Yes.
Since the award holder states that the contract was executed with Union of India, let Union of India be added as a necessary party. Steps shall be taken. List after 4 weeks.
My lord, should we serve in the meantime or should I just execute?
First make them, then I'll.
Great. Will I appear for the petition? But in this matter, my lord, in the section 9 stage, the City Civil Court, my lord, had appointed a receiver who took possession of the vehicle, my lord. Thereafter, the award was passed, my lord. We are in execution, my lord. But all that I was praying that the same receiver, my lord, who is in possession of the vehicle, my lord, would be directed, my lord, to sell the vehicle and, my lord, kindly takes my prayer B in the execution, the tabular statement, my lord. This is appearing for the first time, my lord. Yes.
Take down. The petitioner prays for execution of the award dated
28 July 2025, my lord.
28 July 2025. The application is filed well within 2 years from the publication of the award. Full stop. Service be effected upon the award debtor. Full stop. Affidavit of service to be filed on the next date. Award debtor shall file affidavit of asset giving the details of the assets and other movable and immovable properties with an advance copy to the award holder list on
Deeply appraised. Notice, sir.
No, this is my execution application, my lord. My lord, I appear for the award holder. My lord, this is against the state. My lord, this is an award of 2007. My lord, they challenged under section 34, they failed. Subsequent challenge was made under section 37. My lord, to which, my lord, they partially succeeded, excepting for one claim. All the other claims, my lord, have remained. My lord, today, my lord, I have filed an execution application. My lord, the claim is around 1.5 crores odd, which, my lord, the state has to pay now, my lord, which is on account of the award along with the interest which has been granted in terms of the award.
Your Lordship, so far as the division bench order is concerned, we had preferred a special leave petition. Your Lordship, this had actually appeared before the Supreme Court today. So I am not sure what is the outcome of this. Your Lordship, after 2 weeks, by which time I will know what is the outcome. I can give the diary number. It is 49.
Lord, only one thing I would like to indicate, your Lordship knows, Lord, now the Supreme Court has said that even if, my lord, an SLP is pending and no stay is granted, it would not, my lord, debar the executing court from executing the decree, my lord. Lord, in the meantime, let them, my lord, the executive engineer file the affidavit of assets, my lord.
Your
This
Lordship,
is an award of 2007, my lord. Today we are in 2026.
Your Lordship, I am not sure what is the outcome of your Lordship.
The outcome, my lord, if
only one thing, may I lift this?
If the matter is listed today, we'll keep it. After 2 weeks, we'll.
Your Lordship, that is my only prayer. After 2 weeks, your Lordship passes the
My
necessary.
lord, kindly records that, my lord, there is a matter which is pending before the Supreme Court. So that, my lord, after it is dismissed, my lord, they cannot seek for any further adjournment, my lord.
2nd of April.
Affidavit of service submitted.
We kept in record. No, the affidavit of service, my lord.
Keep it with yourself. We'll keep it not today. We'll keep it on.
No, the only thing I was beseeching your lordship, since it is the state, my lord, let it be recorded that an SLP has been preferred. That is why, my lord, I was beseeching your lordship.
Run away. We'll have it on the 2nd of April.
I'm grateful, my lord. I'm grateful.
I mean, respondent 6. Opposing.
That my application for restoration, my lord, 900 days of.
I'm opposing, my lord. I want to file an affidavit here.
Lord, this was with.
But this application is
Mr.
also not
Gaggar's
maintainable.
office. Mr. Gaggar is the senior most solicitor during his lifetime in Calcutta. Last 3 years, my lord, was dismissed and I didn't inform. So that's the reason. Also, my lord, family.
900 days.
So we came to know after 3 years that the matter had stood dismissed. Then we took change now. In
I want
between,
to
he
file an
died.
affidavit because there are certain documents which are to be brought on record, and this application also is not maintainable.
Hello?
Some of the petitioners have died long time back, is what I've been instructed. I don't know whether.
That's
My lord, I am appearing for the respondent
who
number
has
2.
filed the petition?
My lord, respondent number 2 have been instructed to appear. The
No, no.
number is not yet there because she is an 88-year-old lady and she was hospitalized in early March. My lord. My lord, I am told that the respondent number 1, who's the daughter, and the respondent number 3, who's the son, the address mentioned therein are not the correct addresses, as they no longer work for grain or reside at the addresses mentioned there. If required, my lord, we will provide them with the correct address.
Unless, my lord, the matter is restored, I cannot carry out any amendment.
No, but
that
the
is, my lord.
service should be affected on them.
So you are here.
I am an 88-year-old woman.
So that's what he's saying, that I'm here, but the address is incorrect.
So I can't touch the address,
I am
my
not
lord,
asking for amendment.
till a restoration
I'm
happens.
saying that I'll furnish the correct addresses. Let them serve on the respondent number 1 and 3 also.
You're here.
I am here, my lord, but I'm the mother, my lord, and I am 88 years old. I couldn't even sign the Wakalatnama here today. And my daughter, my lord, respondent number was initially in London. Now she's come back to Bangalore. It is difficult for me to send all these things. Let them serve. They are coming after 907 days. I have also taken instructions that the petitioner numbers 2 and
1, 2, and 4.
1, 2,
1,
and
2,
4,
and
they
4
have
have
died.
died.
And although
The petition is on behalf of all the petitioners.
yes, no, although it is shown as on behalf of all
No,
the petitioners,
governments also.
my lord will.
That you have to find out.
No, let it be, my lord.
Although
We'll
I'll
file
take
an
steps.
affidavit. We'll file an affidavit.
this is, although it is mentioned as sees the master summons, it has been taken out only on behalf of the petitioner number 3, and the affidavit has also been affirmed in that way.
No, there are some problems, my lord.
There are problems which
Because if there is a dead person, in
Can't-
the absence of his legal heirs, there cannot be a restoration also. I will take steps.
That is why I said it was not maintainable.
No, it's, I can't change the cause title. My lord, the proper thing to do is to serve this, my lord, upon, because I can't amend it without the matter being restored. But notice must be given on all legal heirs.
Otherwise, it's not maintainable.
Otherwise, it's not. Notice must be, but I can't change the cause title. So, which is why in the restoration application, I should have said this. I should have asked for a leave to serve the legal heirs and representatives of these persons. Now I have come to know that they are not there. I will have to, my lord, indicate that this is pending to all of them. I'll do that and come back. My lord, please do not even give affidavit directions today.
No, I will not.
Please keep it after 10 days. We will take steps in the meantime.
We'll keep it on 2nd of April.
Samjha?
But I undertake to file Wakalatnama prior to the return.
We are not doing anything. Let
nothing
him
is
come
right.
back on 2nd.
Yes. Grateful. my lord.
Grateful.
Malad, for the applicant, I am the award debtor. Malad. I have
Award holder.
innocuous application again, Malad. This is not complicated at all. I have only sought. Malad has this impression about me that every time I come up with something mischievous, this is really not mischievous. Malad will not take me amiss.
Not
Malad,
mischievous. I don't have that impression at all.
on the
Nothing
last
mischievous
occasion,
about-
no.
Nothing mischievous about you. Yes.
So on the lighter side, Malad. Malad, simple application. I am the award debtor. pursuant to an order passed by a coordinate bench, my lord, I had furnished a bank guarantee to secure the awarded sum. I had furnished that bank guarantee because I have a pending 34 application as well. That bank guarantee was furnished, my lord, on 16 December 2023 with the learned registrar. That was extended from time to time. It was an annually renewable bank guarantee. It expired, my lord, unbeknownst to us, it's a mistake on our part, my lord, no doubt about it. It expired on 16 December 2025.
That's in section 9.
No, my lord. In section 36, it's been passed. In the execution, an order has been passed directing me to furnish a bank guarantee.
So
In this
in this execution,
it is being
order was passed.
Yes,
Figure,
my lord.
file account.
If my lord will kindly
Order
take page 10.
Just a minute.
Yes, my lord.
Let me see the order
I'm
sheet.
sorry.
Which order?
November.
Then you move an application.
This is this application. This is the application. My lord, it will
Which
recall-
order is that?
Yes, my lord. Page 10, my lord, will take 28 November 2023.
Page 10 of your GA1.
Yes, my lord. GA1. GA1 is GA1. Page 10. My lord will find 28 November 2023. Award debtor undertakes to furnish bank guarantee for the alleged awarded amount as on date, inclusive of interest. Let this matter appear on so and so. Thereafter, my lord, the bank guarantee is there. Page 11. My lord will see the date at the top right. Top right, the date is there, 16 December 2023. We furnished this with the registrar. It's taken on record. My lord will directly thereafter come to page 18. 18. 19 December 2023, my lord will see it is submitted by both parties that in terms of the order of court, a bank guarantee for the entire awarded amount has been furnished with the registrar original side. Let this matter appear for further hearing, so and so. Thereafter, my lord, it's been renewed from time to time until page 19. Page 19 is where, my lord, I admit there is it's a bona fide mistake on my part. Page 19, my lord. 18 December 2025, registrar writes to me saying that you have not renewed the bank guarantee. Therefore, the bank guarantee elapsed. Though it's within the claim period, the main bank guarantee expired, term has expired. Thereafter, my lord, I take steps with the bank. I obtain the fresh bank guarantee for resubmission. Page 23, if my lord kindly takes. 24 December 2025. There's been a delay of in total, my lord, from 16 to 24th, 8 days. 8 days delay. 23, page 23, my lord, will kindly take.
Page 23.
Page 23, my lord.
Yes.
Page 23, my lord, will see this is, we confirm to have executed the bank, and this is the renewal, my lord. That's just an advice that's issued by the bank. My lord will kindly see the dates. The date is 24 December 2025, top right. Thereafter, my lord, guarantee valid up to, my lord, will find towards after dear sirs, 5 lines from the top. Guarantee valid up to, my lord, has that line?
Yes, 31/12.
31/12/2026. My lord, this is the second issue that is cropping up. My bank guarantee was extended from time to time from 16 December 24 to 16 December 25. Thereafter, it was supposed to be 16 December 26. Bank has issued in excess. They've given me an extended validity till 31st December 2026. The registrar, my lord, is saying that he will not accept. This is verbally. My advocate on record was there before the registrar. Verbally, registrar has said it has to be a leave granted by my lord to submit this bank guarantee only for this amended period. This would not prejudice anybody. I am granting more than I am required to. I was required to grant a bank guarantee for the period till 16 December 2026. I am granting till 31st December 2026 in excess. Muller will kindly grant me leave, condone my delay of 8 days, Muller, because 24 December I did not furnish the bank guarantee within time. 8 days delay, if Muller will kindly condone. I have my averments, paragraph 15 onwards. I've tried to make my explanation, whatever is there. And Muller will kindly grant me leave.
Supposed to renew the bank guarantee?
16 December 2025.
And you did that on?
24th.
24th.
Yes. I have that. That original bank guarantee is there also with me, which I wrote to. No, that's okay. The bank guarantee itself is dated, Muller, 2020. Yes. 16 December 2025, which is annexed, Muller. That's also part of the annexures at page 23, which I showed, Muller. Yes. 24 December is the date. And thereafter, Muller, we had mentioned the matter. Muller will recall, Muller had directed me to file an application. This is that application. I've tried to, Muller, explain my delay. Muller, paragraph 15 onwards are my explanation in my affidavit in support of master summons. Paragraph 15 onwards, I've tried to explain whatever is there, Muller. I admit this is a bona fide mistake, Muller. 8 days, there was a change in advocates, therefore we had overlooked, Muller. It's a bona fide mistake.
No problem.
kindly fix up the date for hearing of the execution application. Otherwise, they have filed bank guarantee.
That can be done.
As a
I
result,
don't.
we are suffering, my lord. My dues is about 96 lakhs odd.
You're protected.
Yes.
No, my lord,
Lordship,
I'm
it-
not getting that money. I'm
Move an application, furnish a bank guarantee.
2023. They are not taking any steps for hearing of the
In
section
his
34
EP, why will I?
our application.
34 is pending, huh?
34 is pending. Muller will fix it for hearing, whichever date. Give the item. Muller, I'll provide the
Award is of
application
which
number.
year?
Award.
If the award is of August 2014 and the 34 is pending since 2014.
I don't.
Our execution has been filed in the year 2018.
Muller will fix it for hearing. We are not standing in
It
the.
is running in the monthly list as item number 42 and 43.
My lord can fix it. No difficulty.
Take down. GA1. Learned counsel for the
fix up a
petitioner
short
has
date, my
filed
lord.
the present application
Okay, good, sir.
seeking leave of the court to deposit the bank guarantee. Full stop. Learned counsel for the petitioner states that this court-wide order dated 28th November 2023 had directed the petitioner to the deposit to furnish a bank guarantee for the awarded amount as along with interest. Full stop. In terms of the said order, the petitioner had deposited the bank guarantee on 16/12/2023, which was valid till 16/12/2024. Full stop. It is stated by the petitioner, award holder, that inadvertently he could not renew the bank guarantee on time.
Correct.
And that the same came to his notice only by the letter of the registrar, original side dated 18/12/2025, wherein it was indicated that the said bank guarantee has expired on 16/12/2025. Soon thereafter, the award holder took steps to renew the bank guarantee, but the same is not being accepted by the registrar, since there has been a delay in the renewal, 8 days delay in the renewal of the bank guarantee. Full stop. 8 days delay in the renewal of the bank guarantee dated 24/12/2025. Full stop. Learned counsel for the petitioner states that the said delay is unintentional and it's an inadvertent mistake made by him. Full stop. He further tenders apology for being not diligent. Full stop. The delay of 8 days is condoned. The registrar, original side, is directed to accept the bank guarantee dated 24/12/2025 within a period of within 3 days.
It's ready, Muller. We'll submit it today itself. We can go and submit.
Within 3 days.
Within 3 days.
Full stop.
ঠিক আছে. ঠিক আছে.
With the above direction, the present application
Obliged.
stands disposed of.
Kindly direct them.
Before that,
That's a copy after filing the
it's
bank.
part,
guarantee
Muller,
with the register original.
page 23 is
It's a part of this.
Well, after filing, let
we will do so. We will send again, Muller. No difficulty. We'll do so, Muller can.
and kindly fix up a date for hearing of the.
One Muller before Muller has recorded my submissions for the award holder. I'm the award debtor.
Oh, sorry.
It has recorded award holder,
Award
debtor.
Award debtor. Sorry.
Kindly fix up the date for hearing of the execution application, my lord.
Application file with the award debtor कर देना सब जगह, petition हटा के award debtor कर देना.
List mention है, mention क्यों देना? हम लोग कौन
No,
सा?
no, mention karo hoche na. My lord, kindly fix up the date for hearing.
For 34, we have to fix a date, sir. We'll see that.
HON'BLE.
Huh? Until this.
Under the next matter, my learned friend is the receiver.
Gopal? Yes.
My lord, execution, lordship has granted him liberty to sell.
Receiver, my lord, I've sold it, my lord. I'm preparing the sale certificate. My lord will keep it after my lord is back from circuit. I'll have it ready by then, my lord. The sale certificate and the report I'll file by the time my lord is back from. Apply. Deeply.
I'll see you after 2 weeks now.
Deeply.
Tomorrow is there. Tomorrow,
my lord, perhaps